Esther Barron. My name is Esther Barron, and I'm the director of the Donald Pritzker Entrepreneurship Law Center at Northwestern Pritzker School of Law, a mouthful. And there I teach a lot of classes on entrepreneurship and innovation and venture capital, as well as run a clinic, which is kind of like a small law firm within the law school where students do legal work for clients, entrepreneurs. And in connection with that, we do a lot of office hours and workshops on specific topics like the one that we're doing today or that I'm doing today. And today we're going to be talking about setting up an entity. So really one of the first things that a lot of entrepreneurs think about, do they need to set up an entity? And if so, what entity should they set up? So this is going to be a fairly high level conversation just to really start thinking about this issue and how to approach it. Happy to answer questions. So we're going to save time at the end for questions, but if I'm covering something that doesn't make sense and you'd rather have your question answered in real time before we get to the end of the presentation, that's absolutely fine too. Just throw it in chat or raise your hand, whatever is easier. And with that, I will go ahead and get started. So one of the questions that a lot of times clients will ask me, excuse me, is both why to form an entity and when to form an entity. So these two kind of very basic questions. And the why to form, I'm going to start with, why do we need to form an entity? If you don't set up a formal entity, and we're going to talk about what those options are in a minute, by default, you actually are an organization. If you're running the business on your own, you don't have co-founders, you're by default a sole proprietorship. And if you have a business partner, you're running the business with someone else, you are by default a general partnership. In Illinois, as true with all other states, when two or more people come together to run a business for profit and to share the profit, they're by default a general partnership if they don't go to the extra level of diligence to set up an entity. It could be a corporation or an LLC. There's lots of different choices. But if you don't make a formal filing with the Secretary of State and you're running a business with someone else, you are by default a general partnership. And so the good thing about sole proprietorships and general partnerships is they're really easy, right? You just start running the business and they automatically happen. You don't have to do anything. If you are using a name other than your personal name, you have to publish the name that you're doing business as. But other than that, you're ready to go. The downside, and it's a big downside, is that you have unlimited personal liability. And what that means is your personal assets are all at risk for obligations of the business. Sometimes this stuff tends to make more sense with an example. So I'm going to share a call I had with a former colleague, and hopefully this will provide a little illustration as to what I'm talking about. So she called me and said, Esther, I don't think this is a problem, but I just want to run something by you. My cousin called me this morning and he was really stressed out. And I told him, I think it's okay, but I said I would call you because I know you represent a lot of businesses. Now, keep in mind, my friend is a lawyer, so she's also a lawyer. She just doesn't do a lot of startup work or any startup work. So she says, I think my cousin's fine, but let me tell you, let me convey the conversation I had with him. So this is what happened. Her cousin got his MBA and moved out somewhere west to work for a consulting firm, had a great job at a consulting firm, and worked out at a gym in the kind of small city that he was living in. And while he was at the gym, he met a former professional athlete who in that small city was kind of a pseudo celebrity. And he became friendly with this former athlete. And the former athlete said, hey, if you'd like, I could be your trainer. I could train you. And he thought, well, that's really cool to get trained by this kind of celebrity former athlete. So he said, yes, he paid him a certain amount and they started training together. And after a few months, he said to this former athlete, hey, I brag about this all the time at work at my consulting firm and other companies that I work with. And everyone thinks it's so cool that I'm getting trained by you. I could connect you to other people who want to train with you. And we can, you could basically keep most of the money, give me 10% or whatever. And I could get you a lot of clients. And the former athlete said, yeah, actually, I find this kind of fun. So, and I could use extra money. So I'm in. Yes, let's do it. So he even set up like kind of a very informal website where people could put in their information and create a schedule. And it went along really nicely for a while. They both made good extra money. But then he filled the athlete's schedule. There wasn't enough. And the athlete said, hey, thanks so much. This is great. I love the extra money, but you know what? Don't refer anyone else to me. I've got as much as I can handle. It's really, I hardly have any free time. So I'm good. Please don't take on any more clients. And her cousin, who's a business person and was thinking, oh, I hate leaving money on the table. There's still people that would like to work out with you. Hey, what if we get another trainer, a few other trainers to use your training regime? The way you could sort of write out how you train people, and then they could use your name and say they're training people with your techniques. It's not as cool as getting to work with you, but still people could brag about that. And so he said, sure, that sounds fine. So they contacted some trainers and they set this up and put on the website that you couldn't train with this guy anymore, but if you wanted to train under his his formula, then you could be set up with another trainer. So all great. They're both making a lot of money. My friend's cousin is working hard at his job, but very happy to have the extra cash. Until one day, they're having coffee on a Sunday, and the former athlete picks up my friend's cousin, and they go to a coffee shop, and he could tell that the athlete was really excited to share something with him. And he said, I know you think you're the business person, and this has kind of been your brainchild, but I have a surprise for you. I'm also a really good business person, and I have signed a lease for a whole new gym. I've gotten a bank loan. I've ordered hundreds of thousands of dollars of equipment that's being delivered, and we're going to have this new gym. So this is where my friend's cousin freaks out because this is not what he intended, and says, oh my gosh, am I on the hook for any of these expenses? And I see I have some questions. I'll get to them in a second. And she said, I don't think so, because you never agreed to any of this. You didn't even know about it. So how could you be on the hook? And this is where she calls me and says, Esther, can you confirm I'm right and that my cousin isn't on the hook? And I said, well, I'm really sorry to say, but I think your cousin is on the hook, because I think that by default, they were running a general partnership. I looked at their website, and it seemed to me there was a pretty good argument that it was a general partnership. And if a court determined it was a general partnership, her cousin could be on the hook for the whole thing, not even just half, because any creditor can come after a general partnership for all of the liability. Now that partner can then go after the other partner for their half, their share. General partners are liable equally, but third parties can come against whoever has the deepest pockets and then make them fight it out with each other. So disaster, right? This is horrible. And I said to her, he could have solved this problem if he had just set up a corporation or an LLC. And she said, oh, that's great news. That's such great news. Let's do that right now. She's like, I'll pay for it. Let's just set it up right now. And I said, well, that's great for going forward, and we're going to spend time talking about that. But for any liabilities that have happened already, the corporate setting up the entity now doesn't help. It's not backwards looking. It's only forwards looking. So I don't want to scare any, I don't want to make this too, terrifying, but that is the risk of a general partnership, is that you can be on the hook for any liabilities that your partner creates, whether or not you know that your partner was making those decisions. They could get in an accident on the way to a business meeting, and the partnership could get sued. So I think it's probably pretty obvious at this point that I don't think general partnerships are a good idea, or sole proprietorships, because of this problem and issue with unlimited personal liability. Before I move on, I want to just look at the chat and see what I've missed. And someone said LLC. So when I say entity, there are lots of different types of entities, and the ones you named are both entities. I'm really talking about for-profit entities for now. So a corporation or an LLC, and with corporations, you can be a C Corp or an S Corp or an LLC. Those are the primary choices that most of my clients decide among. So that's what I'm going to focus on. A 501c3 is when a not-for-profit corporation applies for tax-exempt status with the IRS, and that's what the 501c3 designation is. I'm happy to talk more about that in the Q&A if people are interested. But for now, what I really want to make sure we're on the same page with is if you don't set up an entity and you're by default a sole proprietorship or a corporation, you have this problematic unlimited personal liability, and you can't fix it looking back. You can only fix it going forward. So the timing is very important, and there are risks in delaying formation, as you can see from the example that I gave you. So people will say, well, when is the right time? And that's a really tough question, because there's no magic clock that says, okay, now you should really move from this, sole proprietorship or general partnership to a formal entity. But what I usually tell people is it's whenever you're starting to do something that could create liability. So when you're hiring people, when you're taking in money, when you're selling something, either a product or a service, these are all flags that what you're doing could create potential liability. So to me, that's when I would start thinking about setting up an entity. So that's the why you do it. And I see I have another question. I have a solo lawn care business and looking to turn it into an LLC, but what happens with the name, the time I have worked with the number of the sole does everything. Yeah, so once you go from a sole proprietorship to one of the more formal entities, you do have to get a new FEIN number. An FEIN number is like the social security number of the entity. So you would have to get a new FEIN number. You wouldn't necessarily have to use a different name if the name's available, and that really goes into trademark law, which I'm happy to talk about in Q&A if we have a few minutes. But that's a separate issue, whether you could use the same name, but it's very possible that you could. Okay, so now we've talked about, the why we do it and when we do it. So now I want to get into how you do it, because a lot of times people can think, okay, I get it. It seems important. But is it super complicated? Is it really hard? How do you do it? And again, I'm going to be focusing on C Corps, S Corps, and limited liability companies, or what commonly referred to as LLCs. And the good news is it's actually really easy. So the process for setting up an entity is pretty simple. I do want to go back in case anyone was worried about my friend's cousin. We actually were able to negotiate with all of those third parties, and he did owe money, but it wasn't a catastrophe, and he learned an expensive lesson and moved on. So in case anyone was feeling sad. But setting up the entity itself. So once you've decided, okay, I don't want the unlimited personal liability, I want to set up an entity, the how is pretty easy. So with corporations, both C corporations and S corporations, it's a pretty simple form. In Illinois, it's called Articles of Incorporation. In Delaware, it's a Certificate of Incorporation. It's a couple pages that you file with the Secretary of State. It's pretty inexpensive. It can range from $100 to a few $100s, depending on what you choose, what type of entity you choose, and what state. But it's a pretty straightforward process. Now, things that can get more complicated down the road are if you have co-founders putting together a founders agreement, vesting of shares, issuing of shares, ownership, intellectual property, all of those things would go into a founders agreement, which does not get filed with the Secretary of State. But just setting up the entity, again, is a pretty straightforward process. You file a 2-page document with the Secretary of State, and lo and behold, once they accept that document and file it and register it, your entity is born and it exists. So depending on what you filed, you may have a corporation or an LLC. And again, there's lots of other choices that I'm not going to focus on today. But the how is pretty easy. The cost is pretty reasonable. And then we get into the where. Where should you file? Where should you set up your entity? And I'm not going to go into, there's, different states have different advantages. Oftentimes, if I have a client who's running the business in Illinois, and there's not other reasons not to set up in Illinois, we'll go with Illinois because we can save money on not having to hire a registered agent, which I'm happy to explain what that is if people have questions. You don't have to pay additional fees for doing business as an out-of-state entity, if they call that a foreign entity. So there could be really good reasons to just form in Illinois. It's simple, and Illinois is usually a pretty good choice. You may have heard that Delaware is a very popular choice, and it is. And so for businesses that are thinking about raising a lot of money, and especially if that money is going to come from venture capital firms, keep in mind that venture capital firms almost always prefer to invest or require to invest in Delaware C Corps. So that's very, very relevant if you're thinking about in the near term, looking for venture capital or VC financing. If you're not, there could be some really good reasons to keep it simple and form in Illinois. I'm going to check the chat again. How do I sign paperwork as the owner of an LLC? So that's a great question. And to maintain the limited liability, there's lots of things you have to do. And one of the things is you always sign contracts in the name of the business, not in your personal name. So the law only gives you this protection that you're not the same as your company, and therefore the liability should be separated if you treat the entities as the entity as totally separate from yourself. So signing contracts in the business name is really important. If you have company credit cards, using the company credit cards just for company stuff, not for personal stuff, even if you were going to reimburse, it's just sloppy. Having separate bank accounts, having contracts and agreements showing that there's a distance between yourself and the company. These are all ways to maintain the limited liability. So someone asked if you work independently. So if you're an independent contractor, you could still create liability. So a lot of times, even independent contractors will set up an entity, and the entity will be hired. So again, they're protecting themselves from personal liability. But it really, in that, will depend more on the situation. Okay, so that's the why, the when, the how. Now we're getting to maybe the most interesting part, which is the what. So I mentioned that there's these different options, but how do you choose between them? And again, I'm going to do this at a pretty high level. Many times, the oldest type of entity is the corporation. That's been around for a real long time. And there's lots of reasons why people like the corporation. One of the great benefits of setting up a corporation is you do get the limited liability protection. So if someone sues the corporation, they're suing the corporation, not the individual owners. In a corporation, we call those owners shareholders. So the shareholders are shielded from liability by the corporation. So that's great. There's lots of reasons why people like corporations. They're easy to set up. They provide the limited liability. This all seems terrific. So you might say, well, then why wouldn't we just automatically set up a C corporation? A corporation. So when you set up a corporation, you're by default a C corporation. That's the automatic terminology is a C corporation. And you might say, that sounds great. Why don't we just set up a corporation and we get the limited liability protection? It's easy to set up. It doesn't seem super expensive. Well, one of the issues with a C corporation that some people can find a disadvantage is the way it's taxed. And again, I'm not going to go into a lot of detail on the way entities are taxed because this is super complicated, but you should know at a high level, C corporations often have what's referred to as double taxation, and that may be a term that you've heard of. And that just means the corporation itself is taxed at the entity level, and then the money that's distributed down in the form of dividends to the shareholders or the owners, once the owners get that money, is taxed a second time, and thus we call it a double taxation. So just to give you an example, if the corporation makes $1, it pays tax on that dollar. And let's say, I don't know what the corporate tax rate right now is, but let's say it's 20%, there's 80 cents left. And let's say then the corporation distributes that 80 cents down to its owner or shareholder in the form of a dividend, that shareholder is going to be taxed on that 80 cents again. So there's this double taxation that can sometimes, oftentimes be a disadvantage. So what do? You may be stuck with the corporation if that's the entity that you've chosen in the C Corp, and you may have that double taxation. But there is another option. When you form a corporation, you can elect with the IRS to be taxed as an S corporation. So again, you form the corporation at the Secretary of State level in whatever state you're filing. You file your articles of incorporation or certificate of incorporation with the Secretary of State. And then if you want to be taxed as an S corporation, you can make an election, an S election with the IRS, which allows you to have what we call pass-through taxation instead of double taxation. So an S corp is not taxed at the entity level. The IRS disregards it. And so the IRS does not tax the S corp. And any money that's distributed down to owners in the form of a dividend to shareholders is then only taxed once. So you might be saying, that sounds great. Why don't we just set up S corporations? Why doesn't everybody do an S corporation? And in some cases, an S corporation is a great choice, but there are some significant limitations on what you can do with an S corporation. First of all, you can only have 100 shareholders or fewer. And for some businesses, that's not a problem. They don't have more than 100. That's not going to be a big deal. All of the shareholders, for the most part, generally speaking, have to be individuals. They can't be entities. So when you're going to raise money, and you may be looking to raise money from an LLC or a fund, they can't invest in an S corporation. It has to be, for the most part, individuals. They also have to be the owners. And again, in corporations, the owners are called shareholders. So the owners, shareholders, have to all be US residents. So there's no flexibility. And then the last restriction that I want to mention that sometimes can be the most problematic is you can only have one class of stock. So oftentimes corporations will issue what we call common shares to their founders, the original people who start the business. And then as investors come in and put money in, they want something better than just the common stock that the shareholders and founders are getting. And so oftentimes investors will get what we call preferred equity. In an S corporation, you can't issue preferred equity. It all has to be common stock. And so that limitation on having just one class of stock can be really problematic for businesses. So what do? Well, if these choices don't sound like they would work, a lot of entities will go for the LLC, the limited liability company. The LLC hasn't been around as the corporation, the C Corp or the S Corp. Can you guys hear my dog barking? Sorry, Ellie. But it can be a really great choice. So the limited liability company also gives great protection. So you have, as the name says, limited liability. So now with an LLC, owners are called members. So remember I said with corporations, owners are called shareholders. With LLCs, owners are called members. And the LLC provides the limited liability protection to the members/owners, just like a corporation does. So it has that great benefit. It also has the benefit of pass-through taxation. So LLCs are considered by the IRS they're disregarded entities. They don't get taxed at the entity level. So the money that gets distributed down to the members gets taxed, but only at the owner level, not at the entity level. So they have this pass-through taxation, which is oftentimes very attractive. And then they also can be really flexible. So there are things you can do with an LLC that you can't do with a corporation, whether it's a C corporation or an S corp. And one thing that sometimes is very attractive to founders is you can allocate profits and losses differently. So you can say for profits, we're going to be 50-50 if there's two owners. But for losses, because one person has a lot of outside income where losses could be really valuable, we'll give that person 90% of the losses and the other person only 10% or even 100%. So from a tax planning perspective, this can be really helpful to businesses to be able to structure where the losses can be the most valuable. And again, that's only with LLCs. one thing to keep in mind with LLCs is LLCs have to issue K-1s to the owners. And so if you do end up forming an LLC, I would suggest working with an accountant. You may feel comfortable doing this on your own, but the K-1s need to be issued, although a tax return is not filed. K-1s taxes aren't paid. K-1s do need to be issued to all of the owners. And that can be a little bit tricky and sometimes not what entrepreneurs and business owners want to spend their time on. So that's the why, how, when, what. And we can go into a couple other options that I want to share. I do want to mention, just so everyone keeps in mind, if you are going for venture capital funding, you want to think about the Delaware C Corp. I mentioned that earlier. But it's important to know that you can change your mind. So we'll have clients set up as an LLC because they wanted to have the tax benefits for a period of time. And when they're ready for outside investors or sophisticated investors or venture capital firms, you can convert. So it's actually pretty easy to convert from an LLC to a corporation. It's more difficult, at least from a tax perspective, to go from corporation to LLC. And now I see I have a bunch of questions in the chat. So let me just take a quick look in chat. So yes, you can go from an LLC to an S corporation, but you would want to work with an accountant because there could be some tax consequences. Usually with Series LLC, that tends to be in real estate deals. It's a way to keep the liability of different real estate parcels separate. There may be other times people use Series LLCs, but from my experience, I usually see them when it's a real estate deal. For an LLC, yes. So for LLCs and corporations, you have to have a registered agent. And I said I would tell you what that was in case people don't know. It sounds more important than it really is. It's just who's the person or company that it's going to accept like official notices from the Secretary of State for your business. And so if you live in Illinois and you set up as an Illinois LLC or corporation, you could act as your own registered agent and put your own information so that notices of, filing requirements or things like that will be sent directly to you. It's also, if you're going to get sued, you have to have on record an address and name where a lawsuit can be delivered. But if you live in Illinois and it's an Illinois entity, you can serve as your own registered agent and save a little bit of money. You can't use a PO box. You have to have an address. If you end up forming your entity in a state that you don't live in, like let's say you decide to do a Delaware LLC or Delaware corporation, you have to hire a company in Delaware to act as your registered agent. So it's not super expensive. It's a couple $100 a year, but that is something to keep in mind. And I see another question, would LLC be beneficial if it's a CNA independent contractor? It could be. So I can't really tell anyone anything specific about their individual circumstance because there'd be a lot of other factors, but many independent contractors that I know have set up as LLCs, and a lot of them have done it as Illinois LLCs, but there's usually other factors that go into that decision. Can a corporation be a shareholder? Yes. So that's one, as long as it's a C Corp. So again, with an S Corp, a corporation can't be a shareholder because owners have to be individuals. But with a C Corp, yes, they can be. Can I form an LLC as an independent contractor? Yes. Miss the where to file. So that's going to be at the Secretary of State. And I'll give you an example, like in Illinois, you can do everything online. So you go to the Illinois Secretary of State, you can open up the form, either the Articles of Incorporation or the Articles of Organization, depending on whether you want to be a corporation, because remember, corporation, it's Articles of Incorporation. For an LLC, it's Articles of Organization. That's the names in Illinois. And you can file them online. You can pay with a credit card online, and it's usually really quick. If you need it super fast, you can pay an extra, I think it's $100 and get it expedited. Otherwise, you can just pay the regular fee, and it's usually less than 2 weeks, and sometimes it's less than a week. So it's pretty fast. Okay, so I'm going to just mention a couple other entities, and then we'll have a few minutes for Q&A. I did want to mention, there's also not-for-profit corporations. So sometimes people just want to set up an entity because they want to have, they have a social mission that they want to further. And setting up a not-for-profit corporation is the right answer. So you can set up a not-for-profit corporation at the state level. Again, you file articles of incorporation. They're specific to not-for-profits. And then if you want to get the 501c3 status, which is what allows a not-for-profit corporation to not have to pay federal taxes, and also allows when people give money that it's a donation that can be, written off on tax returns. They get a tax credit for it. You have to get 501c3 status. So you would file at the state level to form a not-for-profit corporation, and then you'd file what we call a 1023 application. And that application goes to the IRS, and that's how you get the 501c3 status. We could do a whole talk just on that, but that's the high level. There's a newer entity that I want to mention. We hear more and more people say they consider themselves social entrepreneurs, and they're not for profits. They want to make money and they want to own the business. So with a not for profit, the public owns the business. We said with a corporation, it's shareholders. With an LLC, it's members. With a not for profit, it's the public. It's not an individual. But we have a newer option called the public benefit corporation, which allows entrepreneurs who have a social mission to still own the company, but be able to make decisions that not only maximize shareholder profit, which is required in a typical corporation, but to make some decisions that further a social mission. And in fact, if you set up a public benefit corporation, you're required to consider both constituents, your shareholders in terms of maximizing profits, as well as your social mission and making sure you're furthering your social mission with your decisions. There are some customers and investors, as people become more focused on social entrepreneurship, that really are using this as a tool. And it also, it communicates to customers and investors that the entrepreneur really is committed to a social mission. That's really part of the fabric of the business. Okay, so I'm going to now open it up to Q&A. We're going to stop the recording because I know some people would prefer to not have their Q&A recorded. So it's not stopped. So let's see.
Yep, hold on one sec.
Great.